I'm Jeff Rosen. I bring you greetings from the National Constitution Center, which I have been lucky enough to head since June. The National Constitution Center is a wonderful museum and education center in Philadelphia, and we are, as we receive our refreshments, we are the only institution in the country chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And our discussion today is very much in the spirit of the great panels and symposia and debates that we are sponsoring every week and every day on the web and on video and in Philadelphia, and now participating in this great discussion here in Washington. Our topic today couldn't be more important constitutionally, and as Rebecca said, it is this. Should there be a constitutional amendment guaranteeing the right to vote to all Americans? What exactly would it look like? What would its consequences be? Could it pass? And is it a good idea? And we have the dream team of constitutional scholars to debate this question. Richard Briffault of Columbia, the Honorable Jamie Raskin from the Maryland State Senate and AU, Heather Gerken from Yale, and Judge Kenneth Starr from the President and Chancellor of Baylor University. Could not be luckier to have this great group here, and I want to jump in with Jamie because you've been in the thick of this debate. What are the options for a constitutional amendment? Would it be specific to DC? Would it more broadly guarantee the right to vote to all Americans? What's on the table, and what does the language look like?
First of all, thanks to DC Vote, to William and Mary, and Jeff, to you for organizing us together to have this important discussion. Let me try to take a running jump rather than a standing jump at the question and just give a little historical context. The people who live in Washington are the only residents of a national capital on earth who are not represented in their national legislature and parliament. So imagine what it would mean to say that the people who live in Paris would not be represented in the French National Assembly, or the people who live in Mexico City couldn't be represented in the Mexican government, and so on. Just to give you a sense of the human rights implications of the disenfranchisement, which has indeed been going on for 2 centuries, ever since 1801, when Maryland and Virginia had ceded land a decade prior in Congress in the Organic Act, organized the district, and people lost their voting rights for Congress. There's a delegate. Since the early 70s, there's been a non-voting delegate. That's Eleanor Holmes Norton, the distinguished and compelling representative of the people in DC, who's going to be here a little bit later today. And there's also a home rule structure in place. But our subject today is the question of congressional representation. And it's meaningful because the people in DC don't get to participate in all of the national decisions that all other American citizens do, with the exception of American citizens living in the territories, and we'll get back to that also. So that means on questions of war and peace, questions of federal budget, confirmation of U.S. Supreme Court justices, other federal judges, all matters of federal policy. The representative relationship, which we think of as the heart of constitutional democracy in America, has broken down or never really existed for people in D.C. And it's actually twice as bad as that, because Congress is not only the national legislative sovereign for people in D.C., it's also the local legislative sovereign, because it's Congress which ultimately passes upon all local legislation and decides upon the local form of government, and tomorrow could decide simply to revoke home rule and to move to another form of government that's existed before, like the commissioner form of government or what have you. All right, so here we are in 2014, in the first nation on earth conceived in democratic rebellion against taxation without representation, governance without representation. And we've got more than 500,000 people in the capital city who are not in a representative relationship with their own government. So what can be done? Well, there was an attempt to amend the Constitution back in 1978. The D.C. Voting Rights Amendment passed Congress by 2/3 in both chambers. To give you a sense of how far we've fallen in some way in terms of national political visibility and recognition of the problem. And there were many conservative Republicans who supported it, including Jesse Helms, who voted for the D.C. Voting Rights Amendment. It failed in the states with the gathering New Right storm, the New Right went after the Equal Rights Amendment and the DC Voting Rights Amendment at the same time. And so I think it was ratified in only 16 or 17 states before it failed.
What did the DC Voting Rights Amendment say?
DC Voting Rights Amendment said that the district constituting the seat of government shall be treated as though it were a state for the purposes of representation in the U.S. Senate and in the U.S. House. So basically, without removing Congress's police power jurisdiction over the district under Article 1, Section 8, Clause 17, which says Congress exercises exclusive legislation over the district constituting the seat of government, Congress would still control that. Still, the district would be treated as though it were a state for purposes of representation. So that failed. Then the people moved to a statehood strategy. There was a statehood convention in D.C. There was a petition in the 1980s sent to Congress, and Congress has since that time not acted on the petition. There was one vote which Congresswoman Norton was able to get in the early 90s, in 93, I think it was, on statehood. It failed 2-1 in the House of Representatives and did not even receive a vote in the Senate, and there has been no action in Congress on the DC statehood legislation. And the way that would work would be to redraw the boundaries of the federal district called for in Article 1 to just the mall, the White House, the Capitol Service area, and then cede the residential lands to the state of New Columbia, which would be admitted by Congress as a new state. That was the proposal, but there's been no action on it. Nothing's happened. Now, one little bright spot is in a proposal that I worked on with Eleanor back in the 90s. The non-voting delegate from the district and then also the non-voting delegates from the territories won the right to vote in the Committee of the Whole, which is the parliamentary expedient by which Congress does a lot of its action, because the delegates had always been able to vote in the committees, and they agreed to treat the Committee of the Whole as a committee. But in a case called Michael versus Anderson, Congress said that's okay because they're not getting the right to vote on final passage, which seemed to imply this could not be done by statute. You could not give DC the right to vote by statute. There was an effort most recently, and this is really the last thing that was tried, to grant the district a voting representative in the House of Representatives just by statute in a deal with Utah that would have enlarged the House of Representatives by 2 new reps. DC would have gotten one, presumably a Democrat. One would have come from Utah, presumably a Republican, and that deal fell apart essentially over the politics of gun control and gun rights. It was of questionable constitutionality, certainly in federal courts that don't have any real sympathy for voting rights in D.C. And that's probably the last thing I should mention before we set up the constitutional question, which was there was a lawsuit brought by everybody in Washington was for it. The mayor, the council, the people, Alexander versus Daley. And that was the litigation that actually gave rise to the existence of DC Vote, which is a terrific organization which mobilizes people on a citywide basis to fight for the right to vote. And it was set up to support this litigation, which was an equal protection challenge to the disenfranchisement of people in DC, saying, okay, it may be true that Congress gets to govern in the district, but it can't disenfranchise people in the district because of the progress of the one person, one vote principle in Reynolds versus Sims and Westbury v. Sanders, Baker versus Carr, and that it is incompatible with everything we know about voting rights jurisprudence. There's a special 3-judge panel set up, which voted 2-1, even reluctantly by the majority to reject it, a beautiful dissenting opinion by Judge Oberdorfer. It went to the Supreme Court, and just a few weeks before Bush versus Gore, the Supreme Court brushed it aside with only Justice Stevens dissenting from the decision not to take the case. And so basically that's where we are today. And my suggestion, for reasons I can discuss after you give other people a chance to talk, is that we need to be talking about constitutional politics, but I would flip the question over. And the question is not, can America enfranchise D.C. through a constitutional amendment, but can D.C. help to enfranchise America through a voting rights amendment? Because I think what we've seen over the recent period is the weakness of constitutional voting rights in America, not just for people in D.C., but for millions of American citizens in the territories, for millions of disenfranchised ex-felons, people who did their time, served, their sentences, got out, got every other right restored, but are still disenfranchised in 9 or 10 states. And then the weakness of voting rights generally when it comes to issues like the photo ID laws we saw in the Crawford case, the assault on early voting and so on. If we had a constitutional right to vote, which was missing, of course, when the Constitution was written, we would have a much clearer value structure for analyzing these things. And I think that Richard is right when he says, well, it's not necessarily going to solve all of these problems. It's true, but I think it would set up a value structure for beginning to analyze them in a different way than we've seen them analyzed.
Wonderful. Thank you for setting us up so well. Jamie has put on the table a range of constitutional amendments, from a limited DC voting rights amendment to a broad amendment guaranteeing the right to vote to all Americans. Judge Starr, tell us about the history of the voting rights amendments. We have 4 of them, the 15th, the 19th, the 24th, and the 26th. How did they pass, and what can the experience tell us about the prospects for?
Well, each arose out, and let me begin by saying thank you as well. I'm very grateful to be here. This is a subject I've thought about for quite some time, and I had the privilege of co-authoring an op-ed piece with former Chief Judge Pat Wald, focusing on how can, in a very instrumentalist way, the people of the District of Columbia be enfranchised in light of the substantial disenfranchisement, which I think most people of goodwill would say that is a terrible and grievous wrong, to be disenfranchised from full participation in the polity. My simple comment with respect to the historical experience that gave rise to each of the constitutional amendments is that each in its own way was the product, as Holmes would say, of the experience of the people, and was responsive to a situation beginning with the 15th, obviously, the great evil of slavery and the like, but the 15th Amendment said we want to enfranchise those who have been disenfranchised on grounds of race. It was an extraordinarily bold move. It was extremely controversial, including here in this part of the country. Maryland never ratified the amendment. Governor Marvin Mandel symbolically ratified it. I didn't know the governor had the power to do that, but Governor Mandel spoke with great authority, and so he symbolically ratified the 15th Amendment. But by virtue of that searing experience, what we then moved to is the 19th Amendment with the women's suffrage movement, which began really in earnest in the mid-18th century, in the mid-19th century, and the suffragette movement, which was tied closely to the abolitionist movement. So there was this sense of there's a deep moral wrong, slavery, disenfranchisement of women, and the like. And what ensued was a great national conversation over decades. And that's sort of the point I would make, that the conversation has to be a very vigorous one, and it has to be nationwide. And this is perhaps the start of that nationwide conversation about what should the rights of the people of the District of Columbia look like. But what does it mean in the 21st century to be a fully enfranchised member of the polity? I would move on to the 24th Amendment. Let me skip over the 23rd because it is a rich history in and of itself that's more particularistic to the District of Columbia. But in terms of a nationwide perspective, the idea, and this actually had echoes in the 15th Amendment, because so many African Americans had served in the Union forces, and there were very powerful moral voices to the effect that if you're out there fighting for your country, as literally 200,000 African American soldiers and sailors did during the Civil War, shouldn't they have the right to vote? Frederick Douglass made this point in the most powerful, elegant way. And so when we move forward to the 24th Amendment, when there had been an effort, via Congress, just through positive legislation, to enfranchise 18-year-olds, the Supreme Court responds with Oregon v. Mitchell, saying, very deeply divided, that the Congress has the power with respect to the federal voting, but not with respect to voting in state and local elections. A magnificent and rich conversation that we should all kind of go back to every now and then to look at the history from the perspective of very different individuals of goodwill, looking at what does it mean to be a member of the polity, what is the 14th Amendment, the equality measure and so forth. But in any event, in light of what the Supreme Court did in Oregon versus Mitchell, within a year, the requisite number of states had ratified the 26th Amendment. But that, too, was the sense of moral wrong that our young men at that time, now young men and women, are dying in Vietnam. Shouldn't they have the right to vote? And so there is this sense that it is, in fact, the right thing to do, and here's a galvanizing event that causes us to focus on this is the time to do it.
Great, very well expressed. And Richard, Ken says you need a galvanizing event, a national conversation. Jamie has put on the table the possibility of a nationwide amendment that would guarantee the right to vote to all Americans. What would the practical consequences of this amendment be, and is it a good idea?
In some extent, that is the question as to, what would the practical consequences be? Much would turn, I think, on exactly how it's written. When I think, just going through the litany of amendments that Judge Starr has gone through, the striking factor, and it relates to Jamie's initial point, in our Constitution, the U.S. Constitution, the right to vote is all there in the negative, which is to say, reflecting the federal structure, the right to vote in federal elections is sort of piggybacked on the extent the vote was given in state elections, first initially for the House and then the Senate when it became popularly elected. And then the measures, both with respect to federal elections and even state elections, were designed in the negative. The right to vote shall not be denied on grounds of race or on grounds of sex or on non-payment of the poll tax for a federal election or on grounds of age if you're over 18. That comes, the last one comes the closest to being a little more technical because they had to figure out, they didn't say on grounds of age because otherwise you could be two, but what was the legitimate age? And so I think if we're talking about turning it to an affirmative right to vote, we'd actually have to, who gets to vote? And we'd have to pick an age maybe. Are we talking about citizens only? Are we talking about residents? What kinds of elections are we talking about? Federal elections, federal and state, ballot propositions which occur at state elections. So a lot of it would turn on what it's written. But then I think the real issue is the kind of the hot issues today, I think, in thinking about, aside from the district special issue, and the comparable issue might be posed for Puerto Rico in representation in federal elections and some of the other territories. Puerto Rico is not on the continent, but it's an even bigger population, are things like the registration process and what kinds of identification you need to vote. What are the grounds of what early voting, absentee voting, the mechanics of voting, really beginning, particularly since Bush versus Gore. There's been a huge attention to the voting process. I think the proponents of the amendment think that this will cause courts to scrutinize rules that make it harder to vote more carefully. I guess that's the uncertainty as to whether or not, given the fact that at least at the level of doctrine, the Supreme Court has talked about the right to vote as a fundamental right, as the most fundamental right of all, it's highly protected, going back in some ways to the late 19th century, but most importantly since the mid-20th century. And on this I'm actually struck by the issue of the poll tax. The 24th Amendment, which struck down the poll tax, struck it down only for federal elections. It was very narrowly crafted. In some ways it was a descendant of the 15th Amendment because the poll tax had been heavily used for discriminatory purposes. The next year the Supreme Court went ahead and struck down the poll tax everywhere on grounds that violated the right to vote. Not the right to vote in the Constitution, but the right to vote that the court had recognized as fundamental. Now the current court has been clearly less protective of the right to vote in many contexts. But the real question is when right to vote issues under we'll call it the 28th Amendment, would it be the 28th or the 29th? The 28th Amendment, come forward, how will the fact that it's there in the text make a difference in terms of resolving these questions of registration standards, voter ID, state adopts early voting and then pulls back on it, which was a big issue in a number of states in 2012. You don't have to have early voting if you do. When the state government changes, they make it less available, making absentee voting less available. Is this going to change how those are interpreted? And that's an open question. The Supreme Court, you could say the right to vote should be as important as the right to keep and bear arms. And the Supreme Court has recognized now protecting individual right in the Second Amendment. But now we're seeing through the courts how this right is unfolding, and lots of restrictions are still upheld. And the Supreme Court indeed said that in the Heller case, that a lot of restrictions are going to be upheld. So it's, the real question is what difference will it make given the well-established doctrinal protection of the right to vote?
Great. Well, Professor Brevald has expressed real questions about whether a right to vote amendment would make much of a difference. Professor Gerken, let's just squarely ask the question, would it be a good or a bad idea?
Yeah, so it's a little bit odd for a voting rights scholar to get up and say she's against amending the Constitution to add the right to vote, but I am against amending the Constitution to add the right to vote. If I had a magic wand and I could do it like that, I'd amend the Constitution and add a right to vote, including a right for DC voters. But I think that the problem with the move to amend is that it sort of, I think it's quite counterintuitive if you think about it just for a minute. So a lot of my work is on what I call the here to there problem. So we have lots of ideas of what, I agree with everything that Jamie said about what's wrong with the here. And I would love to see the world that Jamie wants to produce with the there, but it's the getting from here to there that is a really tough slog. And I don't need to tell any of you that because you've been working on a discrete issue that turns out to be incredibly hard to get through. Well, that's true of all election reform. And because in most cases for election reform, the people who know the most about reform and the people who care the most about reform are the elite politicians who want to oppose reform, unless it's only in their interests. And the thing that I find so puzzling about the move to amend the Constitution is that the groups that are behind it have had no success or very little success in state legislators and Congress. And so it's sort of like someone who's driving in traffic, can't find a turn, is in a traffic jam, and says, well, let's try for a moonshot then. This right to vote will only go through the same state legislatures and the same Congress that at this point won't even give them smaller things. So the idea of getting the right to vote through Congress and the state legislatures is really tough. Now, the response has always been, if we have the right to vote, which obviously deeply resonates with the American people, you know, it's up there with motherhood and apple pie on the polling front, we'll build a giant coalition that will rise from the grassroots and push the right to vote through and force politicians to do the right thing. And I would love if that were true. And I would love for that to happen. And maybe people as charismatic as Jamie can get it done, but I have my doubts. And the reason I have my doubts is that when you look at the history that Judge Starr was describing, these movements to vote tend to be part of a broader national conversation and a broader movement involving concrete harms of recognition. So suffrage, the right to vote for African Americans, those were about identity and belonging. The civil rights movement, which really made the right to vote meaningful for African Americans, came through a social movement that wasn't just about the right to vote. It was about a broader societal change in how we recognize people. The trouble with the right to vote abstractly is that it doesn't resonate in that same way. So most Americans are in favor of it. But if you ask people, are you going to get out in the streets to protest? The answer so far has been no. And that's in part because it's a little abstract. So, we can tell people, look, the right to vote is really going to matter to you. All the things you care about, the economy, healthcare, those things are shaped by our election system, but it's one step removed for the average everyday person. And so for the average American, it's just too diffuse a harm to get people out there. There's a problem with political elites. So most times movements don't actually kick in until you can get political elites on board. You need some group of self-interested politicians on your side. And with the right to vote, you have this, you're sort of whipsawed by this dilemma. On the one hand, you write something really generic. There shall be a constitutional right to vote, and Congress can enforce it. That's usually what the generic thing looks like. Well, that just gets you to Richard's problem, right? That all the concerns that we have about getting something meaningful through the courts, it doesn't really get you that much. Congress doesn't seem ready to act. It already has a fair amount of authority, and it doesn't do anything. So it's not clear that giving it the power to enforce the right to vote gets you there. The other alternative is you put your laundry list of the goodies that you want. So you add felon disenfranchisement, you add we're against partisan gerrymandering, you add we want to change the election administration system so it's extremely well run. So those are all, really good things. The trouble is each one of those things that puts you gets your tent,